Hello, good evening, and welcome to Unacademy. Welcome to the launch of the fifth phase of Conquer Prelims 2026. In this phase, we will cover current affairs of the period January till April 2026, subject-wise. The schedule has been provided to you already. The PDF of this lecture will be available on my Telegram channel. The link is provided in the video description. In the first phase of Conquer Prelims 2026, we have covered the current affairs of the period January till December 2025. Afterwards, all the current affairs important articles will be covered in phase 5. Ready? Shall we start? If I am audible, visible, please let me know. Perfect. But this particular segment, this particular live session is primarily relevant for those who are attempting prelims 2026. But over the past 1 month, a lot of new learners have joined us who are targeting CSE in 2027 or beyond. For them, there is a beautiful opportunity right now to enroll with us for your GS, current affairs, optional, mock tests, mains, prelims test series. And right now, our subscription is available at 16,999. All you have to do is apply this code IAS English and you can enroll with us. Now let's get started and look at topic number 1, suspension of sentence. An MLA belonging to the Uttar Pradesh Legislative Assembly, he was convicted by the trial court under POCSO Act and sentenced to life imprisonment. Then he filed an appeal before the High Court. High Court suspended his sentence. It proved to be controversial. Later on, matter was taken up by the Supreme Court and Supreme Court imposed a stay on the suspension of sentence. But for your prelims examination, you need to know what is this suspension of sentence without getting into the politics of it. We know that in criminal justice system, you are innocent until proven otherwise. You are innocent until you are proven guilty. But then this logic turns upside down when there are some other laws involved. For example, under Prevention of Money Laundering Act, you shall be deemed to be guilty. Then you have to prove whether you are innocent or not. Similarly, under POCSO, this is what we call reversing the burden of proof. Normally in a criminal justice system, you are considered innocent until proven otherwise, which means the prosecution has to prove beyond any reasonable doubt that you are guilty. But in such laws, such as PMLA, POCSO, you are deemed guilty. You have to prove that you are innocent. But listen to me carefully. Once the trial ends, a person is either found to be guilty or not guilty. If you are found not guilty, you will be acquitted. If you are found guilty, you will be convicted. But once you are convicted, then law no longer treats you as innocent, which means now the punishment starts. Now then what happens? This convicted person can appeal before a higher court. Trial court gave you the verdict. You can appeal before the High Court. Where is this mentioned? This was mentioned previously under the Indian Penal Code. Now, Indian Penal Code has been replaced by the BNS. Under section 430 of the BNS, you can approach the higher court if the High Court decides your conviction can be suspended. This is what we call suspension of sentence, which means what? You won't go to the jail, maybe bail can be granted, but that does not mean sentence has been suspended, but your conviction has not been cancelled. It has only been stopped or temporarily paused. What does that mean? You approach the higher court, you will get a stay on your conviction. That does not mean you are now innocent. You are still guilty, but only the punishment temporarily pauses. You are still guilty in the eyes of the law. Now, when and which are these cases where the suspension of sentence is granted? It depends upon how serious the offense is. There are some short or fixed term sentences. Shorter fixed term, 2 years, 3 years, 4 years. Then there are some serious crimes. For example, if you're sentenced to life imprisonment can be imprisonment for the normal life of an individual, which means you will never be set free. Or it can be 14 years. Or it can be after 14 years, we will review it again. Maybe you will be released after 20 years. So these sentences are not fixed. But if there is a short or fixed term sentence, this is a norm. Normally a norm where your sentence is suspended. That means your punishment is temporarily paused. Unless and until the court decides, that too in writing, that these are the reasons why even in this short or fixed term sentences, we are not suspending the sentence. You have to give the reasons. But normally in such cases, it is the norm. But if there are some serious crimes, especially those which are to be punishable with life imprisonment, then the suspension of sentence is rare. That does not mean it won't happen, but it is rare. In these cases, the judge decides based on how serious the crime was, how was this crime committed, and whether it would be appropriate to release this convicted person on bail. Because in these long sentences or these life imprisonment cases, it is not the norm, it is an exception on part of the judge to suspend the sentence. Listen to me carefully. Individual was Mr. Sengar of Uttar Pradesh Legislative Assembly. He was booked under POCSO, and POCSO is an important law which we will discuss again today. Very important law for upcoming prelims examination. Listen to me carefully. There is something called offense and aggravated offense. For example, someone committing rape, but someone in the position of power committing rape. And who is the someone who is in the position of power committing rape? For example, if you're a teacher, for example, if you're a relative, for example, if you're a public servant, for example, you're a police officer. In these cases, it becomes aggravated offense. Now, the question was whether Mr. Sengar, who is and who was an MLA, whether he would be treated as a public servant, which means someone in the position of power, and in this case, it should not be treated as an offense, but aggravated offense. The argument before the High Court was that Mr. Sengar is an MLA, and MLA is not covered under the definition of public servant. Now listen to me carefully. Another important point for your prelims. Does the POCSO Act define who is a public servant? No. Then what do? We import the definition of public servant from Indian Penal Code or Bharatiya Nyaya Sanhita. Way back in 1984, the court had said that a public servant is not an MLA. MLA is not a public servant. If MLA is not a public servant, Mr. Sengar was an MLA, and as such, it won't be an aggravated offense. On this ground, the High Court suspended the sentence of Mr. Sengar. But later on, it was challenged before the court and Supreme Court stayed the suspension. But from this topic, what is it that you need to keep in mind? Number one, suspension of sentence does not mean that conviction is cancelled. No, it only pauses the punishment, that too temporarily. And it varies. If it is a short or fixed term offense, punishment, in such cases, it is norm. If it is a case involving life imprisonment, then in that case, it becomes an exception, not a norm. That completes our topic number one. Now, topic number two, offenses. For example, we have BNS. These conceptual questions are asked in your examination. For example, once there was a question asked, what is the difference between the judicial custody and police custody? So this is something that you have to keep in mind. BNS, does it talk about petty offenses, serious offenses, or heinous offenses? No. BNS categorizes offenses into whether these are bailable offenses or non-bailable offenses, whether these are cognizable offenses or non-cognizable offenses, whether these are compoundable offenses or non-compoundable offenses. Compoundable and non-compoundable. For example, defamation. You filed a defamation case against me. Matter went to the court. But then we can have an out-of-court settlement between us and you will withdraw the case. So we will settle this case outside of the court It becomes a compoundable offense. But what if it's murder, rape? These are non-compoundable offenses. So BNS categorizes offenses into compoundable, non-compoundable, cognizable, non-cognizable. Cognizable offenses are those offenses where the police can arrest you without a warrant. Police can start investigation without the orders of the magistrate. But if it's a non-cognizable offense, then the warrant by the magistrate is necessary for your arrest. Permission of the magistrate becomes important to carry out the investigation. Cognizable offenses, non-cognizable offenses. Compoundable offenses, non-compoundable offenses. Bailable and non-bailable. But it is the Juvenile Justice Act of 2015 which categorizes offenses into petty offenses, serious offenses, and heinous offenses. Why? Because if you are a juvenile in the age group of 16 to 18 years, and if you commit heinous crimes, then you may be tried as an adult. And that is how Juvenile Justice Act categorizes offenses into petty offenses. And which are these petty offenses? Just keep in mind all those cases where the maximum punishment is up to 3 years. Forgery, theft, so on and so forth. Serious offenses, those crimes for which the punishment is between 3 to 7 years imprisonment, those are serious offenses. And heinous crimes for which the punishment is 7 years or more. Or should we say those crimes where the minimum punishment is 7 years, all those offenses become heinous offenses or heinous crimes. This categorization, this classification becomes important. Right or wrong? Any questions as of now? No, great. Let's look at the third topic, Unlawful Activities Prevention Act 1967. Umar Khalid, Sharjeel Imam, they were denied bail because they were booked under UAPA. And in that case, the Supreme Court, while denying the bail application, spoke about the hierarchy of roles. What is this hierarchy of roles? There are some who are ideologues, who give directions that you should commit this unlawful act, you should commit this terrorist act. And then there are those individuals who actually implement these orders. So the threshold becomes high for those who are the ideologues, who are giving these directions to commit unlawful activities or terrorist acts. And bases this logic of hierarchy of roles, the Supreme Court denied bail to Sharjeel Imam and Umar Khalid. But be that as it may, the point is, this law penalizes unlawful activities as well as terrorist activities. Now, what is the difference between the two? Does the law explicitly define what are these unlawful activities and terrorist activities? Maybe that is a question that can be asked in your exam. And the answer is yes. If you are using words, whether spoken or written, and you are trying to excite dissatisfaction against the government, against the nation, in that case, it becomes an unlawful activity and you can be prosecuted. But if you are trying to do this, but by the use of arms, ammunition, firearms, bombs, IEDs, then it becomes a terrorist act. Till 2019, only organizations could have been declared as a terrorist organization. But since 2019, now individuals can also be designated as terrorists. Individuals as terrorists, this is something which came into force since 2019 when the law was amended. But what are the facts related to UAPA? Any person, even if you commit an offense outside India, you can be booked under UAPA because it will be construed as if you have committed this act within India. That's an important fact that you have to keep in mind. Who is this law applicable to? Even if you are a citizen of India but outside India, this law is applicable. Even if you are a person who is in the service of the government, but whether you are serving the government in India or abroad, this law is applicable on you. Similarly, the persons who are on ships or aircrafts, but these aircrafts or these ships are registered in India, this law is applicable. No matter where the ship is, where this aircraft is, But if this aircraft or a ship is registered in India, the law is applicable on you. These facts are important. Listen to me carefully. How does the central government declare a particular organization as a terrorist organization or an unlawful organization, or a particular individual as a terrorist? If the central government decides, feels that a particular organization has become unlawful or is unlawful, it will issue a notification in the official gazette and declare that this organization is unlawful. But whenever you issue such a notification, important fact, you have to specify on what grounds. Did you declare this organization an unlawful organization or a terrorist organization? But another fact, in some cases, the central government may not disclose any fact if it considers it is against the public interest to disclose this fact. Maybe the central government will issue a notification in the official gazette and declare an organization as a terrorist organization or an unlawful organization. But then you have to provide the reason as well. Maybe the reason will not be provided. Maybe the facts related to this case may not be provided. Why? Because the central government feels that it is against the public interest to disclose such facts. Then what is the role of the judiciary here in this case? In this case, once you are declared as a terrorist or a terrorist organization or an unlawful organization, the matter will go to a tribunal. And this tribunal is created under the law, under UAPA. And this tribunal will be presided over by, important fact, sitting judge of a high court. And once this sitting judge of the high court declares that yes, it was done rightly, that this particular organization or an individual was declared as a terrorist organization or a terrorist, this is valid. This is about UAPA. Important. Unlawful act and terrorist act, as I told you before, defined in the law clearly. But listen to me carefully. Normally what happens, you are declared guilty after the trial is over. Very important point. You are declared guilty after the trial is over, because after the trial is over, once the judge gives the verdict, you are then declared whether you are innocent or guilty. But what if you are charge sheeted under UAPA? That means the matter is still not decided whether you are guilty or innocent, but you are only charge sheeted. In that case, your passport will be impounded. Passport will be seized. So impounding or the seizure of the passport of a person charge sheeted under this act is valid. These facts can be very, very important for your prelims examination. Let's look at another topic which is nowadays in the news, anti-defection law. Anti-defection law, there are facts which you would know, was not originally part of the Constitution, but was added by the 52nd Constitutional Amendment Act. The year was 1985, and that is how 10th schedule got added to the Constitution. Under this 10th schedule, if you are a member of a house belonging to a political party, and if you voluntarily resign from your party, you are disqualified. Clear? If you are a member of a house, and house can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, if you have voluntarily resigned from your political party which gave you the ticket to contest the election, you are disqualified. Or if you violate the whip. But which type of whip? There are 3 types of whip: 1-line whip, 2-line whip, 3-line whip. Only if this 3-line whip is violated, you can be disqualified. But here also there is a condition, 15 days. Do you know about this condition, 15 days? If I violate the whip issued by my political party, but within 15 days of this violation, my political party condones my violation, says it's acceptable to us that he has violated this whip, no action will be taken against me. But once this 15-day period is over, I shall be disqualified. Nominated member. Can a nominated member join a political party after the nomination? Yes, but within 6 months. if a nominated member joins a political party 6 months after the nomination, disqualified. Similarly, an independent member, which means a member who has been elected to a house but not on the basis of the ticket given by any political party. You are contesting as an independent. And as an independent, if you got elected to a house, now you can't join any political party. Because if you do, you will be disqualified under anti-defection law. And who will take that decision? This decision will be taken by the Speaker, if you are from Lok Sabha or Legislative Assembly, will be taken by the Chairperson, if you are from a Rajya Sabha or Legislative Council. Clear? But originally the law said, maybe just to confuse you, this statement may be added in your examination. According to the Constitution, the decision of the Speaker and the Chairperson is final. Is this correct? Yes, because Constitution talks about this. But it is only after the Supreme Court comes into the picture. In Kyoto Holohong case, the Supreme Court said, yes, the decision of the Speaker shall be final, but subject to judicial review. Because final authority may be the courts. The courts have the power to review the actions taken by the Speaker and the Chairperson under anti-defection law. But now listen to me carefully. There are some exceptions to this law. Exceptions? For example, please remember these institutions, individuals. Remember them. Speaker, Deputy Speaker of Lok Sabha, Deputy Chairman of Rajya Sabha. Sir, why not Chairman of Rajya Sabha? Because Chairman or Chairperson of Rajya Sabha is not the member of the Rajya Sabha. And as such, you cannot be disqualified under anti-defection law because you're not the member. Chairman, Deputy Chairman of the Legislative Council. Because in Legislative Council, Chairman is not nominated, Chairman is elected. The Speaker or the Deputy Speaker of the Legislative Assembly of the state. Only these are exceptions. Which means, if they resign, they will not be disqualified. Sir, what does that mean? In simple terms, Mr. Om Birla was given the ticket by the BJP to contest Lok Sabha elections from Kota constituency. Got elected to the Lok Sabha. Now he was elected as the Speaker of the Lok Sabha. After your election as the Speaker of the Lok Sabha, he could resign from the BJP. But normally if a member of a house belonging to a political party resigns from the party, you should be disqualified. But this law will not be applicable if you are a Speaker and you resign. Why is that the case? This is to ensure impartiality of the Speaker. You are a member of the Lok Sabha. You were belonging to a political party, but now you belong to the entire house. And we want you to be as impartial as possible. That does not, however, mean that the Speaker has to necessarily resign. The Speaker need not resign. But if you resign, you will not be disqualified under anti-defection law. One interesting fact. What if you resign, but later after 2 years, you were removed as the Speaker? Or you resigned as the Speaker. Now you have to join the political party again. Can this time you join any other political party? No. You have to join the same political party which gave you the ticket to contest the election. Which means if Mr. Om Birla resigns from the BJP, can he be disqualified under anti-defection law? No. But then after he ceases to be the Speaker, can he join any other political party? Congress, AAP, any other party? No. You have to necessarily join the BJP again. If you join any other political party, you will be disqualified. Now the question is, this is where a lot of students had doubts. Can Speaker also be disqualified under anti-defection law? Yes. On what grounds? Maybe you have defected. You were part of the BJP, but you resigned from the BJP, you joined the Congress. And then you are not giving up the post of the Speaker because now you have the majority in the Lok Sabha. In that case, can the Speaker be disqualified? Yes, under anti-defection law. So Speaker is not beyond anti-defection law. This is where normally there is a confusion. Students assume that since an exception is mentioned for the Speaker cannot be disqualified under anti-defection law. But Speaker can be. But then who will take that decision? any member who is chosen by the House for this particular purpose. That means in that case, Lok Sabha will choose a member of the Lok Sabha to decide just this question, whether the speaker should be disqualified under anti-defection law or not. Clear? But sir, what is this two-third merger? On this, there is no clarity. Clarity in the sense, it was thought, just like what Mr. Raghav Chadha has done, along with two-thirds of the MPs belonging to Aam Aadmi Party in the Rajya Sabha, they have merged with the BJP. If we go by the Constitution Bench judgment of the Supreme Court in the Shiv Sena case, Supreme Court has categorically stated that there is an organization wing and there is a legislature wing. And there is an umbilical cord between them. You can't cut that umbilical cord. For example, in that case, just to resolve your confusion, whip is appointed by the political party. Because who will issue this 3-line whip, 1-line whip, 2-line whip to your MPs? For that, whip is appointed by political party. Can tomorrow these 2/3 MPs of Congress or Aam Aadmi Party or any other political party decide that this whip is removed? We will appoint a different person as the whip. Whip is a political appointee. Supreme Court in the Shiv Sena case has said no. Because this whip has to be appointed by the political party. Because if you cut this umbilical cord, then there is no link between a political party and the legislature party or belonging to those political parties. So you can't do that. So does that mean this two-third merger is valid? In my understanding, it is not valid. It is not valid because for that merger has to take place. Merger has to take place in the sense Aam Aadmi Party and the BJP, they should decide to merge together. But that decision has to be taken by the political wing, the organizational wing of the Aam Aadmi Party. That cannot be decided by the legislative wing alone. The only requirement is if Aam Aadmi Party and the BJP decide to merge with each other, 2/3 of the legislators, they have to accept this merger. Only then this merger can take place. Otherwise, the merger also will not take place. That's the requirement. But be that as it may, let's see how it pans out in the courts. Related to anti-defection law, there is a Mukul Roy case. Unfortunately, Mr. Mukul Roy has died. Mukul Roy, he was initially part of the TMC, but then resigned from the TMC, joined BJP. Did not defect. Now he was given ticket by the BJP to contest the election. And basis that ticket, he became the MLA of the West Bengal Legislative Assembly. Important opposition leader, Mukul Roy, belonging to the BJP, member of the West Bengal Legislative Assembly. Then what happens? According to his critics, he resigned from the BJP and joined the TMC back. Came back to his original political party, the TMC. But what the government did, appointed him as the chairperson of Public Accounts Committee. Sir, what is the link? Public Accounts Committee, CAG, is considered to be the friend, philosopher and guide of this Public Accounts Committee. Right or wrong? Public Accounts Committee examines the audit reports of the CAG when it comes to audit report on the Appropriation Act, on the Finance Act, on the public sector undertakings. It's an important committee of the legislature. It is there in the parliament as well. It is there in the state legislatures as well. But then there is a convention that we follow. And the convention is that the chairperson of this Public Accounts Committee should be from an opposition political party. Since Mr. Mukul Roy was given ticket by the BJP, became an MLA of the West Bengal Legislative Assembly, but now he seems to have joined the TMC again. But the government said, no, you still belong to the BJP, at least on paper. So we will make you chairperson of the Public Accounts Committee. BJP filed a petition before the speaker saying Mukul Roy should be disqualified because he has voluntarily given up his membership. He was admitted into TMC back in a much publicized event. But the speaker said, no, I'm not disqualifying him. Speaker took the decision. Matter went to the court. The High Court of Calcutta said, Mukul Roy, you are disqualified. Why? Because you have violated anti-defection law. And you are removed as the chairman of the Public Accounts Committee as well. In this case, just look at one more point and we are done. High Court relied on something called preponderance of probability. What is this preponderance of probability? Something is more likely to be true than false. So we will look at the facts of this case and then make an assumption. What is more likely to be true than false? And basis that we will decide whether you are right or this person is right. This doctrine or this rule is used to resolve civil cases. Preponderance of probability. For example, this was used in the Ayodhya case. Ayodhya Ram Jannabhoomi case, where the dispute was over the 2.77 acres of land, whether this belongs to Lord Ram or this belongs to the Muslims. The Supreme Court, 5-judge bench of the Supreme Court, invoked this preponderance of probability to decide who is more likely to have retained the control of this disputed land without any break. Was it the Muslims or were it the Hindus who had uninterrupted access to this disputed territory? Basis that we will decide whose land is it. So if a statement is asked in the examination, civil cases are mostly decided by preponderance of probability. The answer is right. The statement is correct. Right? And in this case, in anti-defection law case, the High Court relied on this, that we see some social media posts basis that you were welcomed by TMC back, which means it is more likely true that you have joined the TMC. And basis that, we are disqualifying you. But then this matter reached the Supreme Court and Supreme Court said, no, this is not correct. You cannot decide anti-defection law on the basis of preponderance of probability. You need to give evidence of whether this person has joined the political party again or not. That fact you have to keep in mind. Let's look at the fifth topic, POCSO. This law enacted by the Parliament in 2012. Why? Because we are signatory to and we have ratified United Nations Convention on the Rights of the Child. So this convention was ratified in the year 1992. And once you ratify an international agreement, an international convention, then you are under an obligation. You have to create a law or a mechanism to protect the sexual exploitation of children. And that is how a comprehensive law was enacted in the year 2012. And this law is gender neutral. Now listen to me carefully. What does gender neutrality mean? Gender neutrality, does it mean that whoever is a child below the age of 18, all these children will be protected? Yes. Which means we will protect the girl child as well as the male child under POCSO. But who is going to be the offender? And who is the victim? Listen to me carefully. Is it gender neutral from the perspective of offender as well? Or is it gender neutral only from the perspective of the victim? It is gender neutral from the perspective of the victim 100%. That means victim, regardless whether you are a boy or a girl, we will give you protection. We will protect you under POCSO. But whether females, women can be prosecuted under POCSO, that we do not have a clarity. For the first time, last year, this year as well, for the first time a notice has been sent to a woman who was booked under POCSO. She said, no, she claims that this law is gender neutral only from the victim side. But offender always has to be a man. A woman cannot be prosecuted under POCSO. But the court has to finally decide whether it is gender neutral from the victim side as well as the offender side. So this is where we do not have a clarity yet. This law talks about speedy trial. What if the statement is asked in the examination that under POCSO it is mandated to solve these cases, to resolve these cases, to hear these cases, dispose of these cases within 1 year, the statement is correct. So ensure speedy trial, ensure special courts. Those courts where only these POCSO related cases will be heard. These are some of the defining features of this law enacted by the Parliament in 2012. But what is the definition of the child? Any person who is below the age of 18 is a child. Now, when we say any person, it does not say girl or only boy. It means both girls as well as boys under the age of 18. They are children and hence protected under POCSO. It talks about various offences such as penetrative sexual assault, which is similar to rape. But if this rape is committed, as I was telling you previously regarding Mr. Sengar's case, if it is committed by a public servant or a relative or a teacher or a policeman, it becomes aggravated penetrative sexual assault. If there is no penetration, it can be sexual assault. But if this sexual assault is done by somebody in power, it becomes aggravated sexual assault. It talks about sexual harassment as well, stalking as well. It talks about child pornography. Specific law which talks about child pornography. Watching pornography is not a crime if you're doing it in your private space. But if it is child pornography, it is a crime. Crime in the sense, listen to me carefully. Initially, POCSO said under section 15, very important point, listen to me. If there is any person who stores or possesses child pornography, but you fail to delete it or destroy it or report it, you will be punished with a fine. So somebody who stores child pornography on laptop, on smartphone, but did not destroy it or delete it or report it to the authorities. You have to report it, otherwise you are a criminal. Fine will be imposed. However, if you are in possession of this child pornographic content, but your intent is to transmit it, to display it, to benefit from this financially, you are doing business of transmitting, selling this child pornographic content, punishment of up to 3 years. But how do you know that this child pornographic content which is stored on the phone or a laptop of an individual, you are storing it just for viewing it and not for transmitting it and selling it as part of your business? Long story short, the question before the Madras High Court was, if someone is in possession of this child pornographic content, does that also mean you are a criminal and you will be sentenced to 3 years in jail? Madras High Court said no, there is a difference. Somebody is storing it for business purposes, somebody is storing it only for viewing. But this was overruled by the Supreme Court in 2024. Supreme Court said even if you are in possession of a child pornographic content, you are a criminal. How? Supreme Court said when you are in possession of the child pornographic content, you have control over this content. Control in the sense, you can like it, you can share it, you can transmit it, and you can also sell it. So you have a control. So when you see a particular message which has a child pornographic content and that is sent to you on WhatsApp, the first thing you should do is delete it or report it to the police. If you don't do that, you are a criminal. Why? Because now you are in control over that child pornographic content. Because later you can transfer it, you can share it, you can forward it, you can replay it, and you can benefit from it. So even if you are in a possession of child pornographic content, it is a crime. This term seen, recently seen in the news, deals with, this can be a question in your examination. Supreme Court said, Justice Pardiwala was the judge, he said don't call it child pornography. Call it seen, child sexual exploitative and abuse material. Why? Pornography is voluntary. Porn stars voluntarily indulging in this activity, storing that content, transmitting that content, and benefiting from that. So it's a voluntary act. But a child cannot give the consent. And if you're using a child for these pornographic videos, which means you're exploiting them. So don't confuse it with the voluntary act. Don't call it child pornography. You should call it child sexual exploitative and abuse material, CSEAM. This is the term that you need to keep in mind. Okay. Important features of POCSO: mandatory reporting, because failure is punishable. For example, there is a teacher in the class who notices that there is a boy of a different class, 19-year-old, in a relationship with a girl who is 17-year-old. The teacher has to report it to the police, because it seems that this is even if it's a romantic relationship, but you have to report it. Why? Because it comes under POCSO. That is why there is a talk that these romantic teenage relationships should not be criminalized under the garb of POCSO. But whether that will happen or not, that's the subject matter of your mains examination. Similar to what we see in England, the Romeo-Juliet clause, where the argument is that if the age difference between the boy and a girl is 5 years, then it should not be called exploitation. It should not come under the POCSO. But if the difference is huge, then it is exploitation. If the age of the man is 40 and the age of the girl is 16 or 15, it is an exploitative relationship. But if the teacher fails to report it to the police, it is a crime. You have to ensure that this law is in favor of the child. If you bring this victim to a police station, maybe you would be shocked to see so many police people around you. You will come under a lot of anxiety, stress, tension, and it will have a huge repercussions on your psychological well-being. That is why when you have to record the statement of the child, you should do that at the child's residence or a place of their choice. And when you are taking the statement of this child victim, there should be a trusted psychologist who should be part of this investigation so as to protect this child. And no aggressive cross-examination of the child. What were you wearing? Why were you wearing this? How did he touch you? Where did he touch you? All this may relive the trauma of that child and will be hugely non-beneficial for this child. And that is why no aggressive cross-examination of the child. These are important features of POCSO, can be relevant for your exam. What if there is a statement given in your exam? Because normally we see the pendency of the cases is of a much bigger concern for all of us. There are cases which are pending. There are 5 crore cases pending. And what if the statement says that in 2025, the fast track courts, which are only hearing POCSO related cases, they disposed more cases than were filed in that particular year? You'll be surprised to know this, but the answer is the statement is correct. Why? Because in 2025, these fast track courts, special courts, which deal with POCSO related cases, they disposed of 109% of the cases. That means they disposed of more cases than were filed in that particular year, because previous cases were also pending, piled up. But this statement you have to keep in mind. Clear? Any questions as of now? Any questions? Yes, no, maybe? Fast track courts are special courts. Okay. Paralegal volunteers. Now, who are these paralegal volunteers? You may never have heard about them unless and until you have watched this Suits, where Rachel Zane, she was a paralegal, played by the Duchess, Meghan Markle. But that's a different concept of paralegal. In India, there is a different concept of paralegal. What's the context? December 2025, Supreme Court directed that these paralegal volunteers be appointed at every police station for these POCSO cases. And these paralegals will be there to assist the victim, because there has to be some channel of communication between the victim and the law enforcement agencies, police. Somebody who will feel as if he is on your side or she is on your side, helping you. You need to file this case. Don't worry, you don't have to give any statement right now. You just insist on the FIR. So somebody who knows the law or who can be taught the law and can assist these victims so as to integrate them or interact with the law enforcement agencies. Such individuals are called paralegal volunteers. When did this practice start in India? The year was 2009. NALSA, National Legal Services Authority, it brought a scheme called Paralegal Volunteer Scheme. We should select individuals. We should impart legal training to these individuals, teach them few details about the laws so that they can bridge the gap between the common people and legal services institutions. So that these common people, Aam Janta, they can have access to justice. And that's how Paralegal Volunteer Scheme was launched by NALSA. The year was 2009. Now the point is, which are these groups from which paralegal volunteers can be selected? Teachers, including retired teachers, retired government servants, senior citizens, students of masters in social work and others, Anganwadis, but most importantly, educated prisoners with good behavior, serving long-term sentences in any prisons. What if there is a difficult question asked in your prelims? Under the Paralegal Volunteers program launched by NALSA, which of the following category of Indian individuals cannot be appointed as the paralegal volunteers? In more likelihood, you may say that these individuals may not be allowed. But these educated prisoners who have displayed good behavior and they are serving long-term sentences in prisons, they are also eligible to be appointed as paralegal volunteers. Why? For example, in your family, there is somebody suffering from diabetes or suffering from other ailment. Since you are too concerned about that individual, you research a lot about that disease. And over a period of time, you assume that you're more knowledgeable than a doctor. The next time when you meet the doctor, you tell the doctor from your side, is it this? Is it this? Should we do these tests? Should we do those tests? What if we eat this? What if we don't eat this? So you are now doing so much research, and with GPT coming into the picture, you become almost as an expert of that particular medical condition. Similarly, these are the individuals who have faced the law. They know how lawyers deal, how policemen deal. They would be in a better position to guide these people when they interact with the legal service institutions, provided they are of good behavior. And if you are educated prisoner with good behavior, you can also be appointed as a paralegal under these Paralegal Volunteer Scheme of 2009. But who selects these paralegals? Selecting the paralegal volunteers is decided by a committee. And that committee consists of 3 individuals. At the district level, we have District Legal Services Authority, because we have National Legal Services Authority, State Legal Services Authority, District Legal Services Authority. The chairman of the District Legal Service Authority, the secretary of this District Legal Service Authority, and any other member. These 3 individuals put together, the third person is to be appointed at the discretion of the chairman of this district level Legal Services Authority. And these 3 individuals will select the paralegal volunteers. But most important point is, this selection process shall not be entrusted to any other body. Because who has the power or the authority to appoint these paralegal volunteers? 3 members: chairman of the District Legal Services Authority, the secretary of the District Legal Service Authority, and the third person who is nominated by the chairman at his discretion. These three put together will select the district legal volunteers, paralegal volunteers. Clear? Very good. Let's look at topic number 7, age of consent. Related to POCSO, related to other cases. Look at the history. The age of consent was 10 years according to the Indian Penal Code when it was enacted in 1860. Then came the Fulmoni Dasi case, where this girl, she was subjected to marital rape and ultimately she died. She was only 10 years of age, and later on the law was changed. The Age of Consent Act made the age of consent at 12. Then it became 14, then it became 16, but POCSO raised the age of consent to 18. These facts you have to keep in mind, but listen to me carefully. Initially, Indian Penal Code said, because is marital rape a crime in India? It's not. But the only instance where it is still a crime is if you are committing sexual intercourse with your wife and the wife is less than 15 years of age. So sexual intercourse with a wife and wife being less than 15 years of age, this is a crime. This is marital rape. But if the wife is more than 15, then it is not a crime. This NGO, Independent Thought, and this is according to Indian Penal Code, this institution, this NGO, Independent Thought, approached the Supreme Court, and 2017 Supreme Court reinterpreted this provision. Supreme Court was told age of consent is 18. Marriageable age for women is 18. Then how are you saying that a girl, even if you are a wife, but the wife is 15 to 18, it is not a crime? And if the wife is less than 15, only then it is a marital rape? Supreme Court said, no, we will interpret it to mean 18 years, which means now also, right now, if there is a child marriage and the girl child is less than the age of 18, even if it is marriage, it is still rape. Because something to do with age of consent is 18. Okay, let's look at topic number 8, Central Board for Film Certification, also known as the Censor Board, although the job of the CBFC is to certify films, not censor films. But be that as it may, the point is, if you have to write a book, you don't have to seek the permission of any other authority before you can publish it. But sir, Mr. Narawane, who was the Chief of Army Staff, he was writing his memoir, and then that memoir became controversial. Leader of opposition spoke something in the Lok Sabha that this book is not, this novel or this memoir is not getting released. There is some sort of censorship. Rules may be different for army. But for others, if you have to write a book, you don't have to seek the permission. If you have to sing a song, you have to compose a song, you don't have to seek the permission. But if you have to make a movie and then exhibit it, exhibition of these movies, there is censorship involved. Censorship in the sense, unless and until you show this movie to CBFC, CBFC examines it and then certifies it, only then you can release these movies. Is this constitutional? Supreme Court said in K.A. Abbas case, way back in the 1970s, that this is constitutional. This is a reasonable restriction on your free speech, because films are on a different, slightly different plane when it comes to other forms of creative expression. But be that as it may, this CBFC is a statutory body, not a constitutional body, not a non-statutory extra-constitutional body. It's a statutory body under the Ministry of INB, Ministry of Information and Broadcasting. And it deals with the implementation of this law called Cinematograph Act of 1952. Because films in India can be screened in multiplexes and theatres only after they have been certified by CBFC. What is the composition? It consists of a chairman and members. All of them are appointed by the central government. Where is the headquarter? In Mumbai. It has 9 regional centers as well. Mumbai, Kolkata, Chennai, Bengaluru, so on and so forth. Why? Because if you are making a Kannada movie, why should you go to Mumbai to screen your movie? You can screen your movie, exhibit your movie, or show this movie to CBFC in Bengaluru. Because in Bengaluru, there will be an advisory panel. Regional offices, these are assisted by these advisory panels, and members of these advisory panels are also appointed by the central government for a term of 2 years. These facts are important. Why CBFC becomes important? Current CBFC chairperson is Mr. Prasoon Joshi. But Prasoon Joshi was appointed way back in 2017. The law said CBFC can be constituted by the central government for a period of 3 years or until further orders, whichever is earlier. Not whichever is later, whichever is earlier. So if 2017 CBFC was constituted headed by Prasoon Joshi, the same CBFC is in operation even today while the term was only 3 years. So it should have been wound up in 2020 and a new CBFC should have been established, but that has not happened. There are some who challenge the legal basis of the current CBFC, saying legally they may not have any basis because they were not constituted, reconstituted. Because once your term is 3 years or until further orders, whichever is earlier, then how are they operating? But be that as it may, according to cinematograph rules of 2024, this CBFC board must meet once every quarter. Another controversy is that the last time this board met was in 2019. According to the law, they have to submit annual report and upload it on their website. But their last annual report dates back to 2016-2017. CBFC says we have not put it out on our website, but we have shared it with the Ministry of Information and Broadcasting. Maybe they forgot to upload it. But be that as it may, these facts are important. What if these facts are asked in the examination? The CBFC chairperson and members' term is 3 years. The current CBFC was constituted in 2017. So there is some discrepancy between statement 1 and statement 2. The headquarters of the CBFC, whether it's a statutory body or not, these facts are important. But even important are the changes which were made in 2024. What were these changes? Digital certification process. Instead of coming in person to Delhi or Mumbai or any of these regional offices, you can apply for the certification online to streamline the process, to simplify the process. Then there will be less red tape. And then categories were, age-based certification categories were created. For example, previously, this movie may be rated A, so only those who are 18 plus can watch this movie, otherwise no. If it was universal, then universal, anybody can watch this movie. Then there was UA, then there was specialized. Even if there are children less than the age of 18 who come to watch this movie, but they should be accompanied by an adult, otherwise parental guidance is required. But then more age-based certification categories were created in 2024. Now it is UA 7 plus, UA 13 plus, UA 16 plus. That means if you are 16 plus, only then you can watch it. If you're 13 plus, only then you can watch it. If you're 7 plus, only then you can watch it. And that too accompanied by an adult. Otherwise, without any parental guidance, without accompanied by an adult, you cannot watch this movie. Previously, when you would apply for the film certification, whether UAS specialized, for example, some movies can be screened only for doctors. There was a limit, 10-year limit, that the validity of these film certificates is 10 years. But then in 2024, lifelong validity, perpetual validity was decided by the CBFC, that once we will certify that film, that certification would remain valid forever. 2024 changes said, we will give more representation to women in CBFC board as well as in the advisory panels at the regional offices. At least 1/3 of these members should be women. And just like Tatkal system, I want this passport now, in one day. I don't want to wait for a week. In that case, priority screening of films for an additional fee. You pay additional fee, we will screen your movies, we will certify your movies quickly. We will watch your movies and then certify them quickly. These changes may be relevant for your exam. Okay? One short marathon would be conducted next week. Removal of a judge. Justice Yashwant Verma, now he has resigned. Article 124 clause 4 deals with the removal of the judge of the Supreme Court. And you need to keep in mind that this removal of the judge of a Supreme Court as well as the High Court judge is the same. On what grounds can they be removed? On the grounds of proved misbehavior or incapacity. But it is Article 124 clause 5 which empowers the Parliament that what Parliament you can do, you can regulate the procedure. And where is that procedure mentioned? In the Judges Inquiry Act of 1968. Because Constitution, and in fact this was the question asked in Prelims 2017 as well, when a motion for the removal of the then Chief Justice of India, Justice Deepak Misra, was sought to be introduced in the Parliament, but then it was rejected by the chairperson of the Rajya Sabha. So that time this question was asked. We have seen the tendency of the UPSC repeating the questions, so you might expect a question on this topic in upcoming prelims examination as well. Constitution does not define what is misbehavior, what is incapacity. Constitution leaves it to a law enacted by the Parliament. You decide it, you define it, you tell us the procedure that we need to follow. Constitution says you can be removed based on the resolution passed by both Houses of the Parliament by this type of majority. Majority of the total membership of the House and majority of 2/3 members present in voting. But how this motion is to be taken up, how Parliament will regulate this process, for that there is a law called Judges Inquiry Act. And it is this law which says who can introduce this motion. It can be introduced in Lok Sabha if 100 MPs of the Lok Sabha sign it. It can be introduced in the Rajya Sabha if 50 MPs of the Rajya Sabha sign it. But what if both Lok Sabha as well as the Rajya Sabha admit this motion on the same day? Then we need to set up a committee. Sir, what are you trying to say? I am saying it's this law, Judges Inquiry Act of 1968, which says that this motion can be introduced in Lok Sabha or Rajya Sabha. 100 MPs for Lok Sabha, 50 MPs for the Rajya Sabha. Then if it is in Lok Sabha, you send this motion to the Speaker. If it is Rajya Sabha, you send it to the Chairman. And Speaker or Chairman may either admit or refuse to admit this motion. The Speaker admitted this motion for Justice Yashwant Verma, but previously the Vice Chairperson, the Vice President of India, the Chairperson of the Rajya Sabha did not admit it for Deepak Misra. And the Speaker did not admit it, or the Chairperson of the Rajya Sabha did not admit it for Justice Shekhar of the Allahabad High Court. So this is where there is a discretion. The Speaker may or may not accept it. If the Speaker admits, then there is a committee which needs to be constituted. But what if on the same day, both Speaker as well as the Chairperson accepted this motion? Then this committee has to be constituted jointly by Speaker and the Chairperson. By Speaker and the Chairperson. And what is the composition of this committee? One, we will have a judge of the Supreme Court. Then we will have a Chief Justice of a High Court. Then we will have a distinguished jurist. If this committee, after investigation, because this committee has to decide whether the charges of proved misbehavior or incapacity are correct, incorrect, proven or not proven. If they find it not guilty, then process ends. Parliament cannot take up this matter because this committee has decided that these charges, these allegations have not been proven. But if this committee says yes, charges have been proven of misbehavior or incapacity, then motion will be taken up by the Parliament. But then Parliament will have to decide whether it needs to go ahead with this motion or not, whether it needs to vote on this motion or not. And if they vote by this majority, then final address will be sent to the President. President will issue the removal order. Now listen to me carefully, very carefully. Two things, and you tell me the answer. If you can tell me the answer, that means you're sorted in this topic. When this address is sent to the President, it becomes binding on the President to accept this motion. Why? Because after voting, it does not remain a motion. It becomes a statutory resolution. And a statutory resolution is binding on the President. That's number one. I'll ask you another question. You might have read, and you should have, that there are certain bills which do not lapse upon the dissolution of the Lok Sabha. When Lok Sabha gets dissolved, there are some bills which do not lapse even if the Lok Sabha has dissolved. For example, bills which are originating and pending in the Rajya Sabha does not lapse. Bills which are awaiting President's assent, they do not lapse. Bills on which joint sitting has been notified by the President, those bills do not lapse. You might also have read that a motion calling for the removal of a judge also does not lapse. So this motion calling for the removal of a judge also does not lapse. Yes, sir, we have heard about it. One more question. When this, listen to me carefully, when this motion is passed by both houses of the Parliament, you might have read that once this motion is passed, it needs to be presented to the President in the same session. Why is that the case? What does that mean? If the motion does not lapse, then what is this usage of this phrase that this motion needs to be sent to the President in the same session? Number one, first is motion, which means when you introduce it, once it has been accepted by the Speaker, it won't lapse. Even if the Lok Sabha is dissolved, it won't lapse. But once this motion has been acted upon, it has been voted upon, now there is urgency. Urgency that now it has been voted upon in the same session it was voted upon. You need to send it to the President and it becomes binding on the President to accept it. That means you have to issue the order to remove that judge, which means you can't delay it further. This is to ensure, or this is to tell you, if lawmakers want, they can make the law foolproof. If they don't want it, they want to deliberately ensure that there are some loopholes in the law, they will make a similar law, just like anti-defection law with a lot of loopholes. Maybe the parliamentarians thought, what if this motion is passed by both houses of the Parliament? But where is it mentioned? That in how many days, in how many years, in how many weeks, in how many decades, in how many millennia, we need to send it to the President for removal? Just like in how many days the Speaker has to decide on anti-defection law petitions, in how many days the Governor has to decide on the bills which have been passed by the state legislature. But here the law has been made foolproof. Urgency is such that once it is approved, it is passed by both houses of the Indian Parliament in the same session, you have to send it and present it to the President. And it becomes binding on the President to accept it because it's a statutory resolution. That means in no time, you will have to issue the order calling for the removal of that judge. That's the difference between the two. Right? Very good. And those who haven't yet liked the session, please take a moment to press the like button. Otherwise, I will not continue. What are the instances? Numerous instances. For example, Justice V. Ramaswamy was the first instance. Could not happen because the motion failed in the Lok Sabha. The Congress party voted against, abstained, did not vote. Then Justice Sumitra Sen. Rajya Sabha passed the motion, but he resigned because he thought, why should I enter the history books to become the first ever judge to be removed? Justice Dinakaran, he resigned during proceedings. Justice Yashwant Verma, when we discussed this in the class, I told the students in the class that in my understanding, he will resign even before the motion is taken up in the parliament. Why? Because if you are removed, number one, you will forever be cited in the history to become the first ever judge who has been removed based on the resolution of the parliament. And number two, you will lose your pension benefits. But if you resign, it is just like retirement with compulsory benefits, such as your pension benefits. That is why he resigned. There were other instances where, for example, Justice Pardiwala, who is now the judge of the Supreme Court, or other judges, for them also, Justice Deepak Misra I was talking about, but the process could not be accepted in the parliament. That means the motion was not admitted. These are the only 4 instances in which the motion was admitted. Deepak Misra's motion not admitted. Justice Shekhar's motion not admitted. Justice Pardiwala motion not admitted. But these are the admitted cases. And out of these admitted cases, none of the motions have succeeded. Because in one case it failed, in 3 other cases the judges resigned. And who removes the judge of the Supreme Court or the High Court? The answer is President, not the Parliament. Okay, so keep that in mind. You're approving, your appointment authority is the President, you're removed by the President as well. Topic number 10. Section 17 capital A of Prevention of the Corruption Act of 1988. What is this law? What is this section? Tomorrow you qualify the civil services exam. Let's say you become the IAS officer. Let's say you are the head of a district. And as the head of the district, you have to perform your duties. And your duty is that you have to give, let's say, a housing facility to a poor, some scholarships or pensions or benefits, or you have to sign on a document, whatever, that's your official duty. But there somebody says you have indulged in corruption. And to prevent corruption amongst the public servants, we have the Prevention of the Corruption Act of 1988. But if for every decision that you take, there is an investigation by the police, there can be an FIR against you, then there will come a time where you will drop your pen and you say, I don't want to take any decision. Why? Because the moment I take a decision, somebody alleges that I've committed a crime. I have resorted to corruption. I won't. There will be policy paralysis. To shield such honest civil servants, the law was amended in the year 2018. Section 17 capital A was added to the Prevention of the Corruption Act 1988. According to this section, public servants, whether you are past public servants or present, retired or serving, whenever you take a decision in your official capacity, then police cannot investigate. Police cannot even file a case unless and until approval is given. Who will give the approval? If you are an employee of the union, central government should give the approval. If you are an employee of the state government should give the approval. Or if you are neither the employee of the state government nor the employee of the union government, then those authorities who are capable of removing you should give the approval. Sir, who is not an employee of the state government and the central government? Chief Minister is not the employee of the state government. Prime Minister is not the employee of the union government. which means ministers are not employees. So if the allegation is against a prime minister or a chief minister or ministers, after all, these are also public servants. Who will give the approval to the police? Somebody who is capable of removing you. Who is capable of removing the prime minister? President. Who is capable of removing the chief minister? Governor. And this is how this section was used when Lokayukta carried out investigation against Mr. Siddaramaiah, the chief minister. Because he's a public servant. And the allegation was, as a public servant, you have taken a decision which leads to corruption. For that, police cannot inquire, investigate unless and until approval is given by the authority. Who gave the approval? Governor. This is section 17, capital A. But is this a shield for an honest bureaucrat or a public servant? Or is this a lottery scheme for corruption? I am capable of giving the authority. I am the head of the department. My subordinates, I tell them, you commit corruption after corruption. Don't worry, but give me my share. And if somebody asks for my approval, I won't give the approval. So this looks like a scheme for corruption. Matter went to the court. The Supreme Court gave a split judgment. That's why this topic is in the news. The Supreme Court gave a split judgment. Justice Nagaratna and there was another judge, they gave different views on this. One said it is unconstitutional, the other said it is constitutional. That is why this topic is in the news. But for this particular thing, whether this was a good judgment, bad judgment, that will be the subject matter of the mains examination. What are the facts related to this provision? Is it that always approval is needed whenever you have to investigate a public servant? No. Then what is that instance where no approval is required? If you are caught red-handed while taking bribe or you are attempting to accept bribe from others, in this case, there is no prior approval required. Why? Because you were caught red-handed. But if approval is required, is there a time limit? Yes. Within 3 months, the decision should be taken. Maximum we can give you 1 additional month, but you have to give us the reason why you need 1 extra month to give the permission. What if the approval is not given within this 4-month period? It amounts to deemed approval. That means in 3 months we could not get the approval from the concerned authority. It means the authority has given the approval and now the police can investigate. These facts become important for your examination. And when this judgment was given by the court, split judgment, where one judge decided that it is constitutional because it is meant to protect the civil servant. Other judge said this looks like a lottery scheme for corruption. This report was in the news, Vohra report. 1993, and then there is a connection, Dinesh Trivedi connection, which we will discuss. Who is Dinesh Trivedi? Mr. Dinesh Trivedi is now India's envoy to anyone? Bangladesh. And how is this man related to this report? I'll tell you. 1993, Bombay blast took place. Then within few months, a committee was set up, headed by the then Union Home Secretary, N.N. Vohra. N.N. Vohra later on served as the governor of Jammu and Kashmir for 2 terms. But be that as it may, this report, this committee was tasked, please talk about and tell us, is there some nexus between criminals, terrorists, politicians, bureaucrats? And there seems to be some form of quid pro quo. There are these gangs which get political patronage. Please investigate this nexus or criminalization of politics. This report was given, but then full report was never made public. Mr. Dinesh Trivedi approached the Supreme Court, my lord, please ask the government to release the full-fledged report. Why is only the half report released? Full-fledged report should be released. Then Supreme Court later on dismissed this petition. Supreme Court said, no, full report has been released. But it is only that with this report, there were some annexures which were added. These annexures told us about the details of the politicians and the bureaucrats who had nexus with criminals and the terrorists. Those details need not be revealed. Why? Because it will affect whatever, ABC. So full report has been released, but report with annexures has not been released. So what was this Vohra committee report talking about? The links between the government agencies, officials, political functionaries and criminal syndicates, the D gang. This report was released, and this committee was headed by the then Home Secretary N.N. Vohra. Done? Great. Topic number 12. Right to marry comes under which of the following articles? This question was asked because that year, that particular right was given to us by the court. Right to privacy comes under which of the following articles? That question was asked because that particular year, this right was given to us by the Supreme Court. Similarly, this year, Supreme Court said access to menstrual health and hygiene is a part of Article 21. Why? Because it is linked to bodily autonomy, the dignity of an individual, the equality, the right to education. How? There is a girl child. There is another girl. She comes from an affluent section of the society. She comes from a marginalized, weaker sections of the society. She's on her periods. She's also on her periods, but she has access to sanitary pads. She has access to a bag in which she can keep the sanitary pad, but she does not have access. Will she skip the school on that given day? Yes, she will. Will it not affect her right to education? Yes. Does it not affect equality also because you are then discriminating between girl and a girl? Does it not affect their dignity? If there are no separate restrooms, washrooms for men and women, if you have to use the toilets which are meant for everybody, or you move out, you have to necessarily go out to answer the nature's call or to change the sanitary pads, all this will affect autonomy, dignity, equality, right to education. Hence, right to menstrual health and hygiene is an integral part of Article 21. Supreme Court termed this issue as menstrual poverty. Because if there are no functional toilets, if water availability is a concern, if sanitary products are not available in the washrooms, if there is no safe disposal mechanism as well, it violates the dignity and the autonomy of the girls. And it is this lack of menstrual health and hygiene which is related to, linked with the attendance of the girl child. And that leads to high dropout rates for these girls. That is why it is a fundamental right. But not just this. What is the impact of this verdict? Impact in the sense, this is not just a normal order given by the court that this is a fundamental right. And if this fundamental right is violated, then you can approach us and we will grant you that fundamental right, protect you that fundamental right. It went a step further. Step further in the sense, Supreme Court said states and union territories, you have to ensure that functional gender segregated toilets are provided in every school. And in every such facility, menstrual hygiene facilities are provided. Safe disposal of sanitary pads. Free sanitary pads should be provided. So now it went a step further. It not only declared this right to be a fundamental right, it went a step further saying, how do you ensure the operation of this fundamental right? And not just that, what if you don't comply with it? If government schools don't comply, heads will roll. We may remove the principal. We may remove the district authorities. What if it's a private school which is not following this directive? In that case, that private school may be derecognized. So this judgment becomes important and landmark judgment because this not only specified and gave us another fundamental right, it also imposed conditions on those states and those union territories that you have to ensure that these facilities are provided. And if you don't comply, then action will be taken. Private schools may be de-recognized, government schools will have to face accountability. Heads will roll. Those officers may be sacked if they were unable to uphold this order of the Supreme Court. Clear? Perfect. Let's look at topic number 13. After the tragic death of Shri Ajit Pawar in an airplane crash, his wife Sunetra Pawar became the Deputy Chief Minister of Maharashtra, the first ever women Deputy Chief Minister of the state. But is Deputy CM a constitutional post? Is there something special with this post? Is the oath of a Deputy CM mentioned in the Constitution under Schedule 3 of the Constitution? Is it true that whenever a file is to be sent to a Chief Minister, then this file should be first routed through a Deputy Chief Minister? What are the facts related to the Deputy CM? Those may be important for your exam. The post of Deputy Chief Minister and the post of a Cabinet Minister are same. It's not that Deputy CM will have more sanctity attached to his post as compared to a Cabinet Minister. No. But your sanctity depends upon which portfolio are you managing. For example, when Mr. Ajit Pawar was the Deputy CM, he was also the Finance Minister. Now, Ms. Sunetra Pawar is the Deputy Chief Minister, but she's not holding the Finance Ministry. She is, I think, the Excise Minister, also the Minister for Youth Services, Sports, Awqaf, which means smaller ministries have been assigned to her. So the power which is available to a Deputy CM depends upon the ministry that this Deputy CM is handling, not the title itself. Cabinet Minister is a constitutional post. Chief Minister is a constitutional post. Deputy CM is not a constitutional post. And that is why I say the Deputy CM's actual importance depends upon the portfolio that is allocated to him. The official files that are meant for CM are not routed through the Deputy CM, nor does the latter, the Deputy CM, have access to such files or decisions taken by the CM. This is incorrect. These facts are important for the Deputy CM. Right? Great. Topic number 14, MPLADS. Why this topic is in the news? Because the allegation was that some Congress MLAs, they are suggesting works under MPLADS scheme in different states. Not their own states, but in different states. Is that valid, invalid, legal, illegal, constitutional, unconstitutional? That's something that we will discuss. But first, facts. MPLADS, the scheme was launched in 1993. Members of Parliament Local Area Development Scheme. It is a central sector scheme. That means the entire funding is borne by the central government. Entire expenses are borne by the central government. It's a central sector scheme. It's not a centrally sponsored scheme. But does that mean these 5 crore rupees are given to the kitty of these parliamentarians? You spend 5 crore rupees, take this check? No. Members of the parliament, they can recommend developmental projects. They can recommend works to the tune of 5 crore annually. You have to recommend that this road be created, the school be created, these sanitation parks be created, durable assets be created, water facilities, schools be created. But you can recommend works. Ultimately, the district authorities, they will have to implement this. Initially, this scheme was administered by the Ministry of Rural Development. But since 1994, this scheme is under Ministry of Statistics and Program Implementation. Right or wrong? Right. But facts. Listen to me carefully. If you are elected to Lok Sabha, if you're elected to the Rajya Sabha, if you're nominated to Rajya Sabha, in which region can you recommend works? If you are nominated to Rajya Sabha, since you don't have any constituency, you're nominated from the fields of art, literature, science, social service, you can recommend developmental works anywhere in India. Which means one important misconception that people may have, that MPLADS scheme is only for elected MPs. That's not correct. It is for the nominated MPs as well. And where these nominated MPs can recommend developmental works in any district, anywhere in the country. But if you are elected to Rajya Sabha, any district where you are elected from the state you have been elected to. If you are a voter in Rajasthan, but you are representing the state of Kerala in the Rajya Sabha, you have to recommend developmental works to the tune of 5 crores annually in any district in Kerala. What if you are elected to the Lok Sabha? Now, it may be possible that you're elected to a Lok Sabha and the entire constituency is one district. Then only in that district. But it may be possible that you're elected to Lok Sabha, but this Lok Sabha constituency is spread across 2 districts. More than 1 district. Then in any of these districts, you can recommend developmental works. But does that mean you cannot recommend developmental works outside of these regions? No, you can recommend. And for that, what is the condition? There is a ceiling, limit. You can recommend 25 lakhs in a financial year in those areas which are not covered here. Which means I am a Rajya Sabha MP from Karnataka. I have to recommend I can recommend developmental works to the tune of 5 crore rupees in any district in Karnataka. But can I recommend in Tamil Nadu? Yes. But the ceiling is 25 lakhs per year. That's it. Not more than that. Except in case of calamity. What if there is a calamity? Cloudburst, hurricane, tsunami, earthquakes, storms, floods. In that case, I can recommend 1 crore worth of developmental works in those calamity affected areas. These facts are important for your examination. Yes? Great. Now, President's rule was imposed in Manipur. And then this President's rule was revoked. And now we have a government in Manipur. And unfortunately, there is crisis in Manipur again. There are crises between the Kukis and the Nagas. Previously, crisis between Kukis and Meiteis. But be that as it may, just answer this question on your screen and then your topic is over. Can you answer this question on your screen? You have 1 minute. Okay. Some of you are right, some of you are wrong. Now, this is a PYQ, but a modified version of the PYQ. The PYQ was, which of the following are not necessarily the consequences? And sometimes there are those people who ratify the answer to a PYQ and ultimately write that answer. And some of you have done that here. Which of the following are necessarily the consequences of the proclamation of President's rule in a state? When the President's rule is imposed in a state under Article 356, necessarily the consequence is that chief ministers are removed in that state. The chief minister is gone, the ministers are gone. Does that mean legislative assembly is dissolved? No. Does that mean local bodies are dissolved? No. Local bodies have nothing to do with the President's rule. And initially, the state legislative assembly is not dissolved, it is kept under suspended animation. Suspended animation. And that is what we see in Manipur. The same legislative assembly was not dissolved after the President's rule was imposed. It's not that new elections, fresh elections were conducted in Manipur. No, the same legislative assembly was revived back, came back from suspension, and they elected an MLA, and that MLA became the chief minister. But the point is, President's rule is imposed in a state on what grounds? On the ground known as breakdown of constitutional machinery. But is this phrase, breakdown of constitutional machinery, defined in the Constitution? It's not defined in the Constitution. That is why it is subject to different interpretations. But the point is this. Constitution says President's rule can be imposed in a state on the basis of the report of the governor or even otherwise. That means the report of the governor is not necessary or requirement for the imposition of the President's rule. Even without the report of the governor, the President may say that there is a breakdown of constitutional machinery in a state and President's rule may be invoked. These facts are important for this topic. Let's look at another important topic, topic number 16, booth level agents, BLAs. And this is in news because of the special intensive revision carried out in various states, which first started with Bihar and then subsequently other states, and now is under tremendous controversy in West Bengal. Special intensive revision, what does that mean? That primarily means that electoral rolls are to be freshly prepared. Who has this power of preparation of an electoral roll? That power is with the Election Commission of India. Who gives Election Commission of India this power? Law. Which law? Representation of the People Act 1950. Who gives this power to the Election Commission of India? Article 324 of the Constitution as well, which says direction, superintendence, conduct, control of elections is vested in this body known as Election Commission of India, right? But normally, in this special intensive revision, the role of booth level agents has come under scanner. Who are these BLAs? What is their validity? Do you know about this? Let's discuss. Initially, booth level agents were appointed. By whom? Election Commission of India. When? Only for that year when the electoral rolls are to be revised or updated. Which means right now we need to update the electoral rolls of West Bengal. We will appoint the booth level agents. Who will appoint? Election Commission of India. After the electoral rolls are revised, they are gone. Because they are only appointed for that particular purpose, for that particular year. But later, Election Commission of India said, no, once you're appointed as a booth level agent, you will continue to function. Continue. Unless and until you are no longer the voter of that booth, of that particular constituency. Or if the political party says, we are withdrawing you from this role, which makes it even more interesting. Which means these booth level agents are appointed by the Election Commission, but on the recommendations of the political parties. And political parties choose a voter of that constituency to act as the booth level agent. For what? To assist in the preparation of the electoral rolls. To help people who are not on the electoral rolls to get on the electoral rolls. To help those people who are on electoral rolls but should not be there. In fact, they should be removed. So basically, helping the Election Commission of India purify electoral rolls. And for that purpose, booth level agents are appointed. Long story short, booth level agents are appointed or were appointed initially for the revision of the electoral roll during a particular year only. But later Election Commission of India said, once you are appointed as the booth level agent, you will continue regardless of whether there is a electoral roll revision in that state or not. You will continue. Unless and until you know you are no longer the voter in that constituency, which means now we will have to remove you. Or the political party says, not this person, we will give you someone else to be our booth level agent. One important condition. No government employee or staff of local authority, PSU, can act as booth level agent. No. Government employee can be a presiding officer of a polling booth, but not a booth level agent. These facts are important. Where these booth level agents were in the news. Topic 17, Form 7. And what is this Form 7? You might have read about Form 7. If you haven't, please stay with me. Form 7. Form 7 is used for objection. That this particular individual's name is on the electoral roll, but it should not have been. Why? Because he is not the voter of this constituency. Why? Because he is dead. Why? Because he is less than the age of 18. Why? Because he is no longer the citizen of India. So you are objecting. It's a good thing. Why? Because you are helping in the purification of the electoral rolls. Can I file a Form 7 and say I should not be there in the voter list? Yes. Why my name is in this constituency's voter list or in the state's voter list? I should have been in the voters list of another state. So I'm objecting to my name. Which form is used? Long story short, which form is used where you can object to the inclusion of any name on the electoral rolls? For that, the form is Form 17. But who can fill this Form 17? Only that person who is already in that role. Which means if there are 100 people, these names are mentioned in the electoral roll, somebody who is already on that roll, he can file Form 17. Because if you're already on the electoral roll, I can say I should not be here, I should be somewhere else. If you are here, then you can say I should not be here because I don't belong to this constituency, I don't belong to this state. Can these booth level agents file objections? Yes. Can they file Form 7? Yes. Why? Because they are already the voter of that constituency, of that state. Earlier, only persons from the same booth or station were allowed to file objection. Sir, what is this polling booth? This is a constituency. But in this constituency, there are various polling stations. Those polling stations we call booth. So that means the entire voters list of this constituency, they're divided into various polling booths, polling stations. Initially, only those persons who were from the same booth or station, they were allowed to file objection, which means they were allowed to file Form 17, Form 7. But now, since 2022, any voter in a constituency is allowed to object. Which means this is the electoral roll, but we have another set of electoral roll for different polling booths of this constituency. Now, if your name is here, somebody whose name appears here can file objection. And this is where some people allege that these booth level agents belonging to political parties, they are filing objection for the inclusion of names on the electoral rolls. And as such, it is leading to more and more deletions. We don't have to look into whether SIR is good, bad, ugly, but we have to focus on facts. And the point is, if this, to prevent misuse, because it can also be misused, if there is one individual who is filing more than 5 objections, if there is one booth level agent, or if there is one voter who is filing more than 5 objections, then in that case, the electoral registration officer will have to necessarily step in and personally visit these areas, these 5 individuals whose names have been objected to, and then verify whether they are present or not, dead or alive, whether they are indeed the voters or not. If you are filing less than 5 objections, then electoral registration officer is not required to mandatorily verify all claims of this individual. This we will discuss in great detail when we will talk about the mains examination, because this has an impact on the right to vote of individuals. But for the prelims examination, these facts are enough. Any questions? Okay. Form 17A, Form 17C. So Form 7 is related to filing objections about someone whose name is on the electoral roll. Or if my name is on the electoral roll, I can object. What about Form 17A and Form 17C? Form 17A is this. It's basically a register of voters. What is this register of voters? There is voting in West Bengal. I am the voter. This polling booth is assigned to me. I try to enter the polling booth, but outside that I have to fill this form. This is called register of voters. What is the serial number of this elector? What is the detail of the document that I have produced? Whether I have produced the voter ID card or any other document, I'll give my signature, and this is where the presiding officer will sign. Presiding officer of that polling booth. Long story short, Form 17A tells us how many people enter the polling booth. How many people enter the polling booth? Because as soon as you enter, you have to fill this form. But once you enter, after that, another document is prepared, Form 17C. And this tells us about the voting percentage. Because people entered the polling booth, but after entering, did they vote or not? Did they refuse to vote? Or were they not allowed to vote? Did they refuse to vote? Under Rule 49O, although this rule is no longer valid, it has been declared unconstitutional by the court in 2013. But be that as it may, it is still mentioned in the Form 17C for reasons best known to Election Commission of India. But be that as it may, I enter the polling booth, but now I say I don't want to vote. My dear, you have an option, press nota. But before nota, there used to be another option, 49O. Give me this rule. I want to record that I reject this entire election exercise. I don't want to vote. Otherwise, how would people know? How would we know whether people are in favor of this democratic exercise or not? We can simply say that 50-60% people voted. The remaining, they are not concerned about voting. What if out of these individuals, there are some people who genuinely want to vote, but who will they vote for? Everybody is a criminal, or everybody has cases against him. But I still want to register protest. See, I want to come. I came, but I did not vote, because who do I vote for? Prior to nota, there used to be this Rule 49O, which means I entered the polling booth, but exactly I did not vote. Or I entered the polling booth, but I was not allowed to vote. Why? Because who is not allowed to vote? Inside the polling booth, I decided to hit a presiding officer. I'll be thrown out. Or previously I had decided that I will send my proxy to vote. For example, I am old, uh, differently abled, more than 90 years old, I cannot go to a polling station. I will send my proxy. That proxy has already voted. And I say, no, I also want to vote. I will not be allowed to vote. So there are various criteria such as this. Long story short, Form 17A tells us how many people entered the polling booth. But Form 17C tells us how many people actually voted. Because you entered, but you decided not to vote. You entered, but we did not allow you to vote. Or you entered, but I said EVM is not working. Then we do what? Test votes. We test the EVM. We press the button. We see whether this vote has been registered or not. And then we need to deduct them. Similarly, before we start voting, we have to see whether the EVMs are working or not. Form 17C tells us the actual people who voted. And this Form 17C is shared with the candidates, is shared with the political parties' candidates. The question before the court was whether Form 17C should be openly displayed on the websites. Because the allegation is, for example, the allegation against the Andhra Pradesh elections, that votes were cast after midnight. Some 10-15% votes were cast after midnight. Who voted? This entire picture becomes known once we have Form 17C. Although it is given to candidates, but Election Commission of India says we are not legally bound to publish it on the website. We have shared it with the candidates. You can take it from the candidates. That's Form 17C. Now, topic number 19. RTI and Digital Personal Data Protection Act. A landmark law enacted by the Parliament in the year 2005, which you would know has fueled transparency in India. But Digital Data Protection Act was enacted because a right to privacy became a fundamental right. Sir, what is the link between the two? Under RTI, you can file an RTI application and seek information from any government department, any public authority, and they have to give you information. They have to give you information within 30 days. But if this information deals with life and liberty of an individual, this information should be given within 48 hours. But be that as it may, not all kinds of information can be shared. There are some kinds of information which can be exempted. For example, can you file an RTI application and say, what was the cost that we paid Dassault when we bought the Rafale jets? The government will say, we cannot share this information. Why? Because it will affect the friendly relations that we have with France. We bought Dassault, it was a government-to-government contract. Although Dassault is a private entity, but government of France ensured that we get a good price. And we get the delivery of the Dassault jets very soon. But if we reveal this information, tomorrow Turkey will also ask for the same price. Other countries will also negotiate on the pricing with France, and it will affect our relationship. So there are, long story short, some information which cannot be disclosed, which are exempted from disclosure, or which will endanger the life or physical safety of an individual. There are criminals who want to know where is this person X. We have to kill him. They will file an RTI application and tell police, please help us locate this individual. They will tell you the location, you will go there and kill this individual. It will affect the life and liberty of this individual. Be that as it may, these are the information which are exempted from disclosure. And most importantly, information related to personal information. For example, an RTI application was filed in Tamil Nadu where the RTI applicant said, government, please take a look at all the eligible women who are working in various government departments in Tamil Nadu and those who are not married. Give me that list so that I can choose one and marry that person. Instead of starting an account on the Bharat Matrimony or Shadi.com, Jeevansathi.com, this is the best way and cost-effective RTI application, few rupees, and I can get this information. Because this information was rejected because you cannot reveal the personal information related to individuals. But when RTI Act was passed, there was some acid test. Listen to me carefully. Listen to me carefully. What is this acid test? If larger public interest decides, we can even ask the government, share the information, how much did you pay Dassault for these Rafale jets? Even if it's a sensitive information, exempted information, but if there is a larger public interest involved, maybe we assume that there is corruption, we can even order you to show those details. Even the information which you have received from the foreign government, reveal that because there is a larger public interest involved. Reveal every information, including personal information, if there is a larger public interest involved. Personal information, I can go to the government and tell the government that give me the details of all those individuals who were given free housing. Can the government say, no, this is personal information, I cannot share with you? No, you have to share it because larger public interest is involved. Unless and until larger public interest justifies the disclosure of this information. And there was another test. Any information which cannot be denied to Parliament or state legislature shall not be denied to any person. What cannot be denied to Parliament? Maybe the doctored images of an individual. Maybe the nude images of an individual. It goes against morality to show it to the Parliament. Such personal details cannot be shared. Otherwise, any information can be shared, provided it is of larger public interest. But then Digital Data Protection Act was passed. Digital Data Protection Act amended RTI. You know how it amended RTI? It said information which relates to personal information, full stop. Everything else is removed. Why? Because we have to ensure the privacy of individuals. Because right to privacy is a fundamental right. Now, if you are asking for information related to this individual, it's a personal information. How can you share with it? How can I share it with you? So this entire concept is gone. Now there is no acid test, which means we won't see whether even this personal information is for the larger public interest. Which means tomorrow I can ask for the educational qualifications of an individual, or I can ask for the IT returns filed by public officials to see whether there is an element of corruption or not. They will say that it relates to personal information. And further, what cannot be denied to Parliament or state legislature shall not be denied to any person. This was initially applicable to all the sections, all the provisions of this law, all the provisions of this law. But now we say it is not applicable to all the provisions. It is applicable only to this section, section 8(1)(j). And that is how the matter is before the court, whether this has a chilling effect on free speech. How? Just give me 2 more minutes and I will make you understand what is the chilling effect here. Data fiduciaries, for example, those who collect the data, they are required to collect only the minimum data which is necessary for your purpose. For example, when you download the app, you give permissions to all sort of things. Allow this app to make phone calls for you. Allow this app to read and send messages on your behalf. Allow this app to make and receive phone calls. Allow access to gallery. Allow access to ABC. Right? Now data fiduciaries are required to collect only the minimum data which is necessary. Why should Unacademy app be allowed to take data related to your phone calls, related to your SMS? Right? So minimum data should be allowed, should be necessary. If you violate it, 250 crore fine will be imposed. You can also seek erasure of your personal data. release this, remove this personal data, delete it, erase it. You have to also tell what is the purpose of your data collection. Now, this will have an impact on investigative journalism. For example, if I'm investigating whether this politician and this bureaucrat and this criminal, they have colluded together, I have to seek information about them. If they get to know that I'm writing something on their behalf, writing some personal details about them, even before I write my article, I publish my article, they will tell my newspaper, don't publish it because it deals with my personal information. Now, if I ask the government authorities, please give me information, how many individuals were given ration cards or housing schemes, they will have to ask me, what is the purpose? Why are you collecting this data? Can I tell them, I am collecting this data because I want to expose corruption? Then they won't give me this data. But if I don't tell them, then I can't write the story. So what do? I don't tell them, I take the story. But tomorrow when I write the story, they say that this is not why you collected this data. 250 crore fine. A small journalist, how can he or she pay 250 crore fine? And you have to maintain record. How did you collect this data? How did I collect this data? I have my sources. There are whistleblowers, part of your organization, who have given all these details to me. Now I have collaborated with them and wrote a story. Now when you are asking me, reveal the source, that means I have to give up my whistleblower. I have to give up my confidential sources. Or otherwise I will have to pay 250 crore of fine. All this is making difficult for investigative journalism. And that is why there is an allegation that this amendment by Personal Data Protection Act and its amendment to RTI, it has had a chilling effect. Clear? Great. Let's look at small topic. Just need to know what this case was all about. Maybe can be asked. Mob lynching. Mob lynching in the sense, there are individuals who are lynched by the mob. Why? Because the allegation is that they were cattle smugglers or they were selling beef. On this ground, they were lynched. When all these mob lynchings were happening in different parts of the country, Tehseen Poonawalla approached the Supreme Court in 2018. Justice Deepak Misra was the Chief Justice of India. Justice Deepak Misra said, we are issuing guidelines. All cases related to these mob lynchings or hate crimes, compulsorily FIR has to be registered in every state, wherever this crime takes place. And then we will monitor whether there is any progress on these FIRs or not. And that is how lynching will be curbed and crippled. Because the state has a duty to protect the citizens' lives. When states refuse to abide by these guidelines, Tehseen Poonawalla guidelines deal with A, B, C, D. Mob lynching is the right answer. Maybe can be asked. When the states refuse, some states refuse to follow these guidelines. Matter went to the court again. My lord, contempt, impose contempt on the chief secretary of that state because they have failed to abide by these directives. Supreme Court said, no, we are recalling the old order. Because the general directions that we issued in 2018, these are unimaginable. How can we keep a track? This is like, and the court was right also. Right in the sense, court cannot become an administrator to see whether FIR is filed or not, to see whether there is any progress on the FIR. Court cannot monitor the performance of the state governments on a regular basis like this. And that is why the Supreme Court said the previous order in which we directed that you have to register the cases and we will monitor those cases, it has become unmanageable for us. That is why we are recalling that order. That does not, however, mean that from now onwards, you cannot come to the court if there is mob lynching or cow vigilantism. In that case, we will take it on a case-to-case basis. We will look at the individual facts of that case. We will direct the FIR for that particular case. Then we can monitor that case as well. But we will not be monitoring all the cases registered, because that will put us into the domain of the executive, and that will also violate separation of powers. Clear? So that is topic number 20. Topic number 21. President Srimati Draupadi Murmu had to visit West Bengal. She was not received by the chief minister, not received by any minister. And then she was also angry, hurt, sad. But that's the political part of it. What's the legal part of it? Whenever the president or the vice president or the prime minister visit any state, chief minister should be present to receive them. If chief minister is not present, then a senior minister should be present to receive them. Is it mentioned in any law? No. But this is a convention that we follow. But what is that document which guarantees or which manages how these dignitaries are to be received? That document is known as Blue Book. Visits by 3 individuals: President, Vice President, Prime Minister. When they visit, where do they visit, all the arrangements related to their visit, they are managed according to this book called Blue Book. Who has prepared this Blue Book? Union Home Ministry. Every such book which is prepared has a number. And these copies are given to different set of individuals. At the ground level, in every district, this book is kept in the custody of the district magistrate. And another copy is with the head of the district police, so that they come to know that when president, vice president, prime minister visits our district, what are these arrangements that we have to keep in mind? Because after all, these are important constitutional functionaries. So long story short, their visits are managed by this book known as the Blue Book. And the provisions of this book are strict. And even if you deviate here and there slightly, then there will be an inquiry. The district authorities, the state governments will be asked, please tell us, why did you deviate from this authority? Why did you deviate from this instruction? You seem to have violated the contents, the provisions of this Blue Book. Whoever is going to, according to this book, whoever is going to welcome these 3 dignitaries, President, Prime Minister, Vice President. But where do you welcome them? Maybe at the airport, maybe at the railway station, maybe at the road's entry into the state, or at a seaport. Who is going to receive them at these places? This list is prepared by the state governments and sent to the secretariats. If the president is attending your state, visiting your state, list is prepared by the state government, sent to the president's secretariat, that Mamta Didi or a senior minister or a senior functionary will be receiving you at the airport or at the seaport or at this entry. But then whoever name you give, that should be approved by the president's secretariat as well. And once it is approved, what if, to embarrass the prime minister, you send an enemy of the prime minister to receive the prime minister and say, this is West Bengal's representative to receive you at the airport? The prime minister's secretariat will have to approve it. And once approved, only those individuals need to be present there. No one else. And which is that book which manages all these arrangements? Which talks about all these arrangements? Blue Book. Who prepares it? Home Ministry. That's it. Okay, great. The Supreme Court upholds right to die for a man in vegetative state. In Aruna Shanbag case, way back in 2011, Supreme Court has declared right to life with dignity is a fundamental right. Right or wrong? Right. Then again, in the year 2018, in Common Cause case, the Supreme Court said right to die with dignity is a fundamental right. And in this particular case, the Supreme Court talked about right to living will. But for the first time, this was put to use in the Harish Rana case this year. Harish Rana, unfortunately, he fell from the fourth story of his PG in Chandigarh. And then since then, the family is taking care of him. He was not on the ventilator support because in passive euthanasia, you need to switch off the ventilator support and the patient may die. But in this case, he was not on the ventilator support. Even then, the family approached the Supreme Court saying, allow this person to die with dignity because there is no hope for his survival. But he's not on the ventilator support. But the fact is that we are using tubes, Ryle's tubes, to give him food. That is what is keeping him alive. If we can stop this food supply, this individual will die and will die the death of dignity. The Supreme Court used its power under Article 142 and allowed passive euthanasia for Harish Rana despite the fact that he was not on the ventilator support. The Supreme Court in this case also waived the 30-day reconsideration period. What does that mean? Family has to be in agreement that this particular individual should die the death of dignity because he is in a permanent vegetative state or he is in a terminal medical condition. 3 doctors also have to certify that yes, there is no hope for survival or he is living the life of misery. Then 2 judges of that High Court will have to give this order and this euthanasia can be taken care of. But once the judge gives the order, you have 30-day period. Maybe in this 30-day period, you will back out. You'll say, no, I don't want to further continue with this. I want to take care of this particular individual. But in this case, even this 30-day reconsideration period was waived off because the court said you don't need it because for many years you have been wanting to effect the death of your child because he is living the life of misery. What is important in this case is the Supreme Court said it's not that in passive euthanasia cases, listen to me carefully, it's not that in passive euthanasia cases we have to decide whether death should be given or not. We have to decide what is in the best interest of an individual. So even if there is a chance that you may survive, you may recover, but right now you are living the life of misery. And even if you survive, you may not live the life of happiness. We have to decide a condition, a future course of action based on what is in your best interest. Which particular medical treatment is for your best interest and decide accordingly. And in this case, we decide for your death and that is how for the first time this passive euthanasia judgment, this common cause judgment was implemented when Mr. Harish Rana was allowed to die with dignity. That is this case. Now topic number 23. OBC creamy layer case. What is this case? I'll simplify it for you. There was reservation for SCs, there was reservation for STs, and then because of the Indra Sani case, also known as the Mandal case, OBC reservation was granted. It was granted by Mr. VP Singh's government, but then court had to decide in Indra Sani case whether OBC reservation is constitutional or not. But in this judgment, Supreme Court listed down certain conditions that you can give reservation to OBCs, but only for those who are from non-creamy layer. But how will we decide who should get the OBC reservation, who should not get the OBC reservation? For that, in 1993, the Department of Personnel and Training prepared an OM, Office Memorandum, and said these are the people who will not get OBC reservation. Which means even if you are an OBC, but your father or your parents were the President of India or Vice President or judges of the High Court, judges of the Supreme Court, children of class 1 and class 2 officers, whether directly recruited in the central or state government, or officers who are part of the armed forces, for example, of their rank above than the colonel. Even if you are OBC, but your children will not get the benefits of the OBC reservation because you are from creamy layer. Reservation will be given only to the non-creamy layer individuals. But for others, apart from these people, are there others also who are part of the OBC but belong to the creamy layer? Yes. For them, we will perform a test called income or wealth test. But listen to me carefully. Here we are talking about class. You are from OBC, but your class is President of India. You will not get the benefit. Vice President of India, you will not get the benefit. Judges of the Supreme Court, judges of the High Court, class 1, class 2 officers, rank of colonel or above in the army. So we are not talking about your income, we are talking about your class. And if you belong to this class, you will not get reservation benefit. But similarly, there are people who are working in central or state public sector undertakings. For them, equivalent posts are not created. In the sense, if we can know that these are class 1, class 2 officers in the state government and central government, IS officers, IPS officers. These are the posts in the army, colonel or above. These class of people will not get reservation. Do we have similar class 1, class 2 posts in central or state public sector undertakings? We haven't. We don't have. These posts have not been created. So for them, we will go for income or wealth test. And what is this income or wealth test? We will see what is your parental income. But we will exclude the income from salaries and agricultural land. But in 2008, 2004, Department of Personnel and Training said income for salaries will also be counted to determine whether you are from creamy layer or non-creamy layer. If you have income above 8 lakh, you belong to creamy layer, you will not get reservation. If you have income less than 8 lakh, you are from non-creamy layer, you will get reservation. Now imagine, just imagine. This is a person with class 1 or class 2 who is part of central government or part of the state government. Right or wrong? Here is an individual belonging to central or state PSU. And this individual is earning 8 lakh. This individual is earning, but he is part of the creamy layer. This particular individual, just because he is earning more than 8 lakhs, we declare him to be part of the creamy layer. But can we equate this post to the post of an IAS officer? No. For this particular group, Supreme Court gave the verdict. Children of those parents who are holding posts in central or state public sector undertakings, but for them, equivalent posts with the government have not been created. That means we can't equate these posts with class 1 or class 2 posts in central or state governments. Here, if you apply only the income test, since your salary is more than 8 lakhs, you won't get the benefit. This would be violation of Article 14 because the same set of people are treated differently. So income alone will not decide. If you want long story short of this, those children whose parents are in the central or state public sector undertakings, but holding those posts, and we don't know whether these posts correspond to class 1 or class 2 because equivalent posts have not been created. We have not said that class 1, class 2 means this particular post in a public sector undertaking. For children of such parents, income alone will not decide. Unless and until the central government, state governments create equivalent posts. You categorically state that these posts in central public sector undertakings or state public sector undertakings correspond to class 1, class 2, then holders of such post will not get the reservation. Others, they will get the reservation. That's what the Supreme Court said in 2026. Topic number 25, recusal of judges. Another important case. Mr. Kejriwal is and was asking a judge of the Delhi High Court, please recuse from hearing my case because you have attended the meetings of the RSS and as such you will be biased against me. The judge said, no, I will not recuse. And she gave good reasons as well. But what about recusal of judges? Matter was before Supreme Court as well. But in another matter. In Anup Baranwal case, we have couple of topics, 2 topics. After this, there is 1 topic and then we are done. So stay with me. In Anup Baranwal case, Supreme Court said till the time Parliament enacts a law to decide how Chief Election Commissioner and election commissioners may be appointed, President will appoint CEC and election commissioners based on the recommendation of a committee. This committee will consist of Prime Minister, Leader of the Opposition and the Chief Justice of India. Parliament later on enacted a law and said instead of CJI, it will be a union minister nominated by the Prime Minister who will be the 3rd member of this committee. Right or wrong? Right. Jai Thakur approached the Supreme Court and said this law should be declared unconstitutional because PM, LOP, union minister, even then the composition is tilted in favor of the ruling party in power, and as such it violates free and fair elections. Now Supreme Court has to decide. Chief Justice was asked, please recuse yourself because you were part of this committee before. And now you are not part of this committee. How can you decide whether you should be part of this committee or not? This violates the oldest maxims of natural justice. You cannot be the judge in your own case. The Chief Justice of India said, okay, I will not be part. I am recusing myself. Not only me, any other judge who will become the Chief Justice of India cannot hear this case. Because not every Supreme Court judge will become the Chief Justice of India. Which means those who will become the Chief Justice of India, for example, Justice Pardiwala, Justice Pancholi, Justice Nagaratna, they should not be part of this bench to hear this case. But in India, there is no law which explicitly talks about recusal of judge. In United States, it is explicitly mentioned in United States Code that the judge will have to recuse himself if their impartiality is questioned. You have to recuse yourself according to this section 455. But this is not explicitly mentioned in any law in India. Recusal is a voluntary act. We saw this in NJAC case as well, where it was to be decided whether NJAC is constitutional or we will go back to collegium. Justice Kehar was the Chief Justice of India. Justice Kehar was told, please recuse yourself. Don't hear this case because there is conflict of interest. You may be biased to strike down NJAC. You may be biased to revive back collegium because you are having a conflict of interest. Justice Kehar refused. He said, we are the 5 judges hearing this case. Why are you only asking me to recuse? What about these 4 other judges? Some of them will also become the Chief Justice of India. So you should point fingers at them as well. Number 1. Number 2, doctrine of necessity. When the only forum which is available is also the forum that faces a conflict, then conflict must yield to institutional obligation. See, you have a conflict of interest, we have a conflict of interest. We are the judges. But who can decide this case? Only the judges. So the clash is between the only forum which is capable of resolving this clash. Then in that case, we have to defer to this institutional obligation. We have to decide. And we are deciding, I will not recuse. Why? Because we will be impartial even then. And what if you are asking Chief Justice of India to recuse? Chief Justice is the master of the roster. Which means who will assign this case to other judges? Chief Justice of India. So if you think Chief Justice of India is biased, he will favor judiciary and not the executive. He will basically assign this case to those judges who will favor the judiciary and not favor the executive. That means they are still biased. But more importantly, this case was when the Chief Justice of India said, not me and no other judge who is going to become the Chief Justice of India will hear this case. It was criticized, saying recusal is an act of individual judicial conscience. It cannot be mandated by a predecessor. The current Chief Justice of India cannot mandate in advance that my predecessors also should not be hearing this case. Okay? Topic 25. Hamsa Nanduri v. Union of India 2026. Maternity Benefit Act was passed in 1961, according to which for 2 children, the mother will get maternity relief, paid maternity leave of 12 weeks. This law was later amended in 2017. And 2017 said you will get paid maternity leave for 26 weeks. But only for 2 children. Does that mean if you have a 3rd child, you will not get maternity relief, maternity leave, paid maternity leave? No, you will still get, but not for 26 weeks, but for 12 weeks. Long story short, under the Maternity Benefit Act, for up to 2 children, you will get paid maternity leave for 26 weeks. For more than 2 children, you will get it for 12 weeks. But Code on Social Security, which was passed in 2020 but got implemented recently, it replaced the Maternity Benefit Act. And these rules say, what about adopting mothers? I'm not a biological mother. I have not given birth to this child. If I had given birth to this child, I would have been entitled to 12 weeks or 26 weeks of paid maternity leave. But I'm an adopting mother. I'm adopting a child. Rule said if you're adopting a child who is less than 3 months old, you will get 12 weeks of paid maternity leave. But if you're adopting a child who is more than 3 months old, you will not get the leave. Hamsa Nanduri approached the court and said, what logic is this? It takes more than 3 months to even complete the formality of adopting a child. So naturally, whenever I will adopt a child, it will be more than 3 months old. By that logic, I will never be entitled to a leave. She approached the court and Supreme Court said, adoption is an expression of reproductive autonomy and it is also your fundamental right. Another important judgment. Right to menstrual health and hygiene is a fundamental right under Article 21. Right to adopt is also an expression of your autonomy under Article 21 of the Constitution. Because if this mother is not given this paid maternity leave, then the burden on helping or providing for care to this adopted child will more likely happen on the girl child if you have another girl child. And then there's a vicious cycle. Maybe a question or statement be asked in your examination that Supreme Court has directed the central government to provide for paid paternity leave. But it has not declared it. It has not impressed upon the government. It has not directed the government. The Supreme Court has only pressed the union government that please ensure or please try and see if paternity leave also be granted. Because we have 26 weeks of paid maternity leave, but not paternity leave. Central government gives 7 days paternity leave. State governments give 7 days paternity leave. Although there are experts who say, don't call it maternity leave or paternity leave, call it parental leave, which should be given to both set of parents because you also need father's presence for a child. In this case, there was a tinge of judicial activism that Supreme Court has now interpreted the Constitution and said maternity leave for working women is a basic human right. And this maternity leave should not only be given to a biological mother, but it should also be given to a mother who is adopting a child. And that is why it becomes a basic human right. Topic number 26, double membership. Mr. Nitish Kumar, who was an MLC, then became the member of the Rajya Sabha. Can you hold both the positions at the same time? Now he has resigned as the MLC. He is only the member of the Rajya Sabha and he is no longer the chief minister either. But this raises a potential current affairs related topic for your prelims exam. Double membership. 2 seats in one house. Mr. Rahul Gandhi got elected to Amethi, got elected to Raebareli as well as Wayanad. That means 2 seats in one house, and the house is Lok Sabha. Can you occupy both the seats? Can you be the members of both the constituencies? It amounts to double membership. You have 14 days to decide which seat you want to retain, Wayanad or Raebareli. What if you don't decide within 14 days? Both seats become vacant. Now, both houses of parliament, you have been elected both to Lok Sabha as well as Rajya Sabha at the same time. At the same time. Can you occupy both the seats? No. You have 10 days to decide. What if you don't decide in 10 days? Then your seat in the Rajya Sabha becomes vacant. What if you are a sitting member of one house, you become elected to another house? Here the condition is different. You are elected to both the houses at the same time. You have to choose. If you don't choose, your Rajya Sabha seat becomes vacant. You will remain the member of the Lok Sabha. Because after all, if you are removed from Lok Sabha, then there is fresh election to Lok Sabha. It amounts to torture of the voters because then they will have to come out and vote again. But what if you are already a member of the Lok Sabha, now you got elected to Rajya Sabha, your Lok Sabha seat falls vacant. Immediately your first seat becomes vacant. You were already a member of the Rajya Sabha. Now you got elected to Lok Sabha. Why did you contest Lok Sabha election if you were already the member of the parliament? In that case, your Rajya Sabha seat becomes vacant and Lok Sabha seat continues. Can you become the member of the parliament and the state legislature at the same time? And can you retain both the seats? No. You cannot be the member of the parliament and the state legislature at the same time. If you have been elected to both, you have 14 days to decide. Otherwise, your seat in parliament becomes vacant. Your seat in parliament is vacated unless within 14 days you resign from the state legislature. Because if Nitish Kumar would not have resigned from the state legislature within 14 days, his Rajya Sabha seat would have fallen vacant. This is double membership. Clear? Done. Now, last topic, topic 27, SC/ST status for converts. And please listen to me carefully. This case was not about a reservation benefit. This was about this Law Atrocities Act. Pastor, he was previously SC. Later converted to Christianity, became a pastor. But then he filed a case under the Atrocities Act of 1989. Under the Atrocities Act, if I am a Dalit or a tribal and somebody practices untouchability, then Atrocities Act case can be filed. This pastor approached the police for filing this case under the Atrocities Act. The police refused. He went to the High Court. High Court also refused. Why? Because you are a convert. And when you converted, even if you were SC previously, you converted to Christianity, Constitution Schedule Caste Order 1950 explicitly talks about religion. If you are a Hindu or a Sikh or a Buddhist, only then you are an SC. You may have been SC previously, but now you have converted to Christianity, you are no longer an SC. And as such, you cannot file a case under the Atrocities Act. Plus, you are not an ordinary Christian. You are a pastor. You have not only professed that you belong to Christianity, you are openly displaying your religious feelings. And you are a practicing Christian. Just because you have shown your SC certificate that previously you belong to the Madiga caste, which is an SC caste in Andhra Pradesh, that does not mean it will override the fact that you are an openly practicing Christian and a pastor. You cannot file a case under the Atrocities Act. Plus, in Christianity, there is no basis of a caste. The very theological foundation of Christianity is they don't recognize any caste. And as such, you cannot file a case under the Atrocities Act. Way back in 2004, a case was filed before the court which continues even today, that whether those Dalits who converted to Christianity or who converted to Islam, whether they will still get the SC reservation. That matter is still pending. And for that, the central government in 2022 set up a committee headed by former Chief Justice of India, Justice K.G. Balakrishnan. This committee was given multiple extensions, and finally, maybe in this year, in this month, April, the report will be given. And on the basis of this committee report, the court will decide whether these Dalit converts to Christianity or Islam, whether they will get SC reservation. So this order of the Supreme Court is related to the Atrocities Act, whether a convert to Christianity or Islam can file a case under the Atrocities Act. Court said no. Why? Because only a Dalit or a tribal can file a case under the Atrocities Act. But this was about SC status. Now, if this pastor, can he reclaim the SC status? Yes. First, you have to prove that you were originally a Dalit, an SC. Then you have to reconvert to that original religion, which means revert to the original religion. And then this group, the SC group, they will have to accept your membership back. You have to assimilate with that group. Once these three conditions are satisfied, you can reclaim your SC status. Basically, if you do Garvapsi, you can retain the SC status, otherwise no. Basically, only Hindu, Buddhist, Sikh, SC can file a case under the Atrocities Act. But what about tribal? Yes, there is no religion-based exclusion in the Scheduled Tribes Order of 1950. The Scheduled Castes Order of 1950, it explicitly talks about religion. Only a Hindu, Christian, only a Hindu, Sikh and Buddhist can be a scheduled caste. But who can be a scheduled tribe? Anybody. So scheduled tribe has nothing to do with religion. Anybody can claim to be a scheduled tribe if you are a scheduled tribe. That means if you belong to that tribal identity, if you are maintaining those practices of that tribal identity, if you have been accepted by that tribal community, which means Christians can also be tribals. Muslims can also be STs, but only Hindu, Sikh and Buddhist can be an SC. Others cannot be the SC. But tribals can be Hindus, Christians, Jains, Buddhists, Muslims. Can you reclaim your SC status? For that, these three tests have been prescribed by the court. This was about all the important topics which were in the news between January till April 2026, which can be relevant for your upcoming prelims examination. If you have been benefited by this lecture, please let me know in the comment section. And thank you for staying with me. Do not forget to subscribe to our channel if you haven't yet. All the best for your prelims exam, and we will meet very soon with a marathon on entire syllabus of Indian polity. Thank you for being with us. Good night.